Well, welcome to Mock Trial 101. We had a number of emails earlier in the registration process where people said, okay, can we have some help on how things actually work here in the Iowa Mock Trial? So this webinar is as a result of that. We hope that it records nicely, and we will archive it on the website for anyone who would like to watch it at a later date. My name is John Wheeler. I work for the Iowa State Bar Association. I run their Center for Law and Civic Education. One of my responsibilities is to organize both the middle school and high school mock trial programs here. So we are pleased by the increased interest in middle school mock trial this year. I noticed that of the participants who signed on for this webinar, quite a few of you are brand new. Others have only a few years of experience, so I'm really glad that, the program is still growing. First, I want to tell you what the webinar will not talk about. You've all had a chance to look over this year's case, I'm assuming. This webinar will not help you with that. In the past, we've had programs for teachers and coaches and focused specifically on the content and legal aspects of the case. This one is designed to focus on the process, not the case. So if you have specific questions that are case related, you could certainly email them to me at some other time. But the focus of this webinar will be on the process and how to get kids active and involved in the mock trial. I'm joined by three experts today who will all contribute to the program. Let me see if I can get this thing. It's not working. There we go. Sorry. Oh, that's right. Christy wanted me to, before we started, to indicate on your homepage or go to webinar page, there's a hand. I guess that means you can raise your hand. If you can hear me just fine, go ahead and raise your hand on the webinar page. Christy, where is that located? By the top of your web page, and it looks like a hand. If you would click on that, that tells us that you are receiving this loud and clear. So we are joined by three experts. They all have special interest in this particular program, but they also have tons of experience outside this particular program. I'll let each of them introduce themselves as it becomes their turn and through the agenda. But we're joined by Christina Thompson, who is one of the co-chairs of the Iowa State Bar Association Young Lawyers Division Mock Trial Committee. She's an attorney here in Des Moines practicing with Phil Watson, PC. John Landy is the other co-chair of the Young Lawyers Division Mock Trial Committee. He is also here in Des Moines practicing with the firm of Dickinson, McMahon, Tyler, and Hagen. And then Van Everett, who is a committee member with the Mock Trial, ISBA YLD Mock Trial Committee. That's a mouthful. He also is an attorney here in Des Moines with Whitfield and Eddy. There's a chance that that many of your students have seen these three as judges in the past, or if you've attended a competition, I'm sure that you will recognize the three. They're constantly around the tournaments as judges and as expert assistants throughout the tournament. I also wanted to talk about how to ask questions as we go through the process. On your web page, there is an opportunity to hit the Ask button and then type your question in, and we will monitor those questions and feed them to whoever is doing the presentation at the time. There are two other ways that you can ask questions that may be more efficient, especially if you're computer illiterate like I am. You can send me an email, and my email address is on the screen. You also have it, or should have, email from me probably today with the case update. I'm also going to regret this, but I'm also adding my text number, 515-720-4015. I'll ask that after today's webinar, you go ahead and forget that until the regional competition. But you can go ahead and text questions, and we will feed those questions again to the appropriate expert as they're addressing. I wanted to go through the basic agenda. We're going to spend just a very little bit of time on the first two, what is mock trial and what are the elements of mock trial. We assume that if you are involved in this webinar, you understand the magic of mock trial and know how the process basically works and are looking for something deeper than that. But I do feel an obligation to at least start at the beginning and then go. We are going to focus more, starting with number 4, on getting organized. How do you start a team? How do you assign roles? That sort of thing. Talking about resources for learning, rules of evidence and procedure, resources for crafting good witnesses, how a mock trial round works if you've never seen one before, and how that process is determined. I'm talking a little bit about the scoring guidelines and how the students are evaluated on their performance, the cooperation between attorney coaches and teacher coaches, some perennial problems that we can easily do away with if we address before the regional competitions begin, navigating the tournament, and then any other issues that you have. This webinar is scheduled for an hour and a half. I hope that we're able to get through most of this material. If we don't and you have any lingering questions after the webinar, please do send me an email, and I will either be able to answer that directly or I will forward it to the appropriate person. So let me start first of all very quickly with the idea of what is mock trial. Mock trial is a simulated courtroom trial where the students are the actors, both the attorneys and the witnesses. It began as an alternative assessment technique in classroom, an alternative to pencil and paper tests. It also serves as a performance assessment or a culminating activity to a unit on the law or the judicial process. Over the years, it has had great success as a competition. I always say that if I could offer this program without the competitive aspect, I would do it in a heartbeat, but I also know that we would lose 3/4 of the students involved. Number one, I think competition drives the motivation, and I think number two, having a date certain where you're expected to perform in front of a strange audience kind of puts the fear into students and motivates them even more to actually do what you hope that they will do. So I tend to downplay the competition, but it is a competition, and ultimately there will be teams that advance on in that competition. Most cases when you first receive it have the following elements. As you noticed when you received this year's case, it did not have a fact summary. A lot of times I will leave those fact summaries out, especially if the case is very oriented on the facts, because the first thing you'll want to do with your team is to kind of create a timeline or an agreed set of facts. There's a petition and an answer, the petition by the plaintiff, the answer by the defense counsel. There are legal authorities. In this case, there are jury instructions. Sometimes there's code sections from the Iowa Code as well. There are stipulations, which I just added to this morning. Then there are the witness statements. There are 6 witnesses, so each of those have a statement that can be used as the basis for the witness testimony. And then the exhibits. Some of the exhibits are more useful than others, and that is one of the strategies for your team to figure out which exhibits can be used with which witnesses and which exhibits are merely thrown in there as red herrings. As you noticed, most cases cover some ripped from the headlines content. This case this year is also one of those instances where there have been a number of injuries in extreme obstacle races recently, and so that's what inspired me to write the case. But they're also designed for you to be able to welcome in experts from a variety of fields to work with the students, and so it becomes cross-curricular as well. There are a number of objectives that we hope are obtained. The knowledge objectives, we hope that you end up with a greater knowledge of court process and specific laws. I suspect that by the end of this year's competition, you all will be experts in gross negligence and wrongful death, probably knowing more than most every attorney in the state unless they specialize in that area. I know the year that we did a trademark or patents case, we had more expert patent attorneys at the middle school level than we had throughout the entire state of Iowa. There are also skill objectives, and I think this is where the skills is really where the magic happens. The students will develop some great hands-on opportunities to put their their skills to work. And then finally, there are attitudes and values or dispositions where we hope that students develop an appreciation for the rule of law, for the roles of the people who work in courtrooms every day, and the idea that issues have multiple points of view. So a student who is a plaintiff at 9 o'clock in the morning will be a defendant at 1:30 in the afternoon and have to understand both sides of that case. We also hope that they give it overall a positive experience with the judicial system. A lot of youth, a lot of young people, their first exposure to the court system is very negative as they go through the juvenile justice process. This is to combat that and give students a more favorable view. And then it also is a chance to get people from the community involved in your classroom. And I think our experts today will talk a little bit about that relationship between the teachers and attorneys specifically, but also looking for opportunities to bring in a wider base, perhaps someone from your community that's run one of these races and can kind of give firsthand experience and help with the characters for your witnesses. I'm going to stop right there and then introduce Christina Thompson, who will be first up to talk about some of the specifics. I think Christina, would you like me to leave the flow of the trial or go back to the outline?
We could just go back to maybe the front cover page.
Okay. There we go.
Okay.
It's all yours.
Okay, I'm Christina Thompson. As John said, I work with Phil Watson PC here in Des Moines. I have been coaching for a few years, but I also competed at the college and the law school level, and I'm, what John often calls a mock trial junkie. So I love doing it, and I love helping out. I'm going to be talking today from the perspective of an attorney coach. I actually don't have a teacher coach who works with me. It's all me. It's me and a parent. Dan Everett will also be giving some perspective as an attorney who works with a teacher coach in a very established program. So hopefully I can give you, a couple different perspectives on how mock trial can be done. The first bullet point I'm going to go over is kind of getting the team together and assigning roles. I'm going to assume that at this point you probably have students who are interested. If you don't, you're going to want to, get flyers out in the school and get them signed up and probably hold some sort of audition just to see what they can do. If they're all brand new to this, then improv games, acting, have them read a monologue, anything that can give you an idea of how well they speak and how well they can process information and think on their feet is going to be really useful to you. When we actually get the team together, how I start to break down the case with my kids is that, number one, I tell them to read it. They have to come to the first practice having read the case. They're not all going to do it, but if you set that expectation, most of them will. If you also assign to them a particular part of the case that they're responsible for, that can increase the number of them that actually read the case before you start. As far as assigning roles, this is really tricky when you don't know the kids. I always meet with my kids, even though I've had them for 4 years now, and I go over what their goals are for the year, what they think they need to work on, and what their interests are. And then I get from them like their top 3 roles they would want to do. And then I go off with my parent coach and we distribute the roles, keeping in mind what I think the kids are going to do well at, where I think somebody might need to improve at, because that's a huge key to mock trial is personal improvement, and also what they're interested in, because if they're interested in it, they're more likely to put the work in. And I found that even when kids get their second or maybe even their third favorite role, they're usually still really excited because they know you took into consideration what they wanted. And I would just advise that you spend some time getting to know your kids before you assign roles if this is the first year. Read the case, go through the case with them, see how they process information, do some acting games, do some improv games. Don't assign the roles right away if it's your first year because you don't know these kids. My first year, I wound up having to shuffle roles 4 weeks in once I learned the kids. And so if you just kind of hit the pause button a little bit, that would be one tip from me, that if it's the first year with these kids, just kind of get to know them a little bit and get an idea of what you think they might be capable of. The next point is scheduling. Have a team meeting, require the parents to be there, and ask them to bring their calendars is the most efficient way to pick a date and time for practices. Doodle polls also work, but then you're reliant on everybody finding time on their own to respond. You can also lay out expectations at that first meeting, and you can have a conversation with the kids about their goals. Because scheduling and the amount of time you put into this program is really going to depend on what your kids want to do. If your kids just want to have fun and learn something about this program and about the legal system, you know, one practice for 2 hours a week might be enough to get them up on their feet. If your kids are really gung-ho and they want to do well and they want to try and get to the state competition or place at the state competition, they're going to need a minimum of 8 to 12 hours a week. And that is a huge commitment for young kids. And so you have to have a really good discussion with them about what they want to do, about goals as a team and individually, and you need to try and gauge where they are, where they want to go, and then what your schedules can accommodate. Another thing to consider is going to be if you have an attorney who's interested in helping you out, if you found someone, you need to consider their schedule, because telling them, hey, our kids meet, you know, from 3 o'clock to 4:30 every day, that might be very difficult for that person to make work with their business schedule. So you have to kind of balance all those things, and having a meeting where you get everybody in one place is what I found to be the easiest thing, and then the parents are hearing the expectations at the same time the kids are. As far as the initial approach to breaking down the case, once you have everybody read it, go over it as a team. It works really well to have that point kid explain what the affidavit was about, what the petition was about, that kind of very basic information so that everybody at least understands what's happening. The next big thing that I do with my kids is we do an outline, and I think we can pull up an example here. Christy, how do I get out to the...
Are you getting us, you want to get to the web or to that?
The Word document, yeah.
If you click on it.
Oh, down there, okay. There it is.
Just click on that. Yeah.
Okay, thank you. So this is an example of the outline of proof that I did with my students for the 2014 middle school case. So you can see here that we took directly out of the jury instructions what the...
Still trying to show that one.
There we go. Okay. So this is an example of an outline of proof. There are a lot of different ways to do it. If you have an attorney who's willing to give you even just a little bit of time and they have a way they do it, that might be a good resource. You can Google these as well and get a lot of examples. There's also charts.
Shut that PowerPoint off.
Sorry, we're trying to get it to show properly. Okay. So we start with the essentials for recovery, which you'll find in the jury instructions, and then we just break them down. So we took Part A, failure to supervise, monitor, etc., and then we just took each witness and we put the page and line number of every single fact that supports that thing we have to prove. And we did this on both sides of the case. It takes us about 8 to 10 hours right now to do this. But I have found, based on years where I didn't do this versus years where I do, it's a lot easier for the kids to then draft directs and crosses and opens and closes because they've already processed what facts they need to pull. And it can also become a working document for your team over the course of the year because as they find new things, they can add to it. And then, you know, the crosser on the other side may be able to deal with that now because the director found it and added it in. So this should be a working document. It should be updated as you find new things. So you can see we went through the witnesses and put the facts from each witness that would support that point. We also listed the exhibits that we thought would help prove that point. So that's one way you can start thinking through what exhibits you need. And we just go down through each element like that. Just witness and exhibit, witness and exhibit. You know, noting the pages or the page and line number so you can find it again. One of the most frustrating things is finding a little tidbit and forgetting where you found it. So, so that's my outline of proof example. Is the PowerPoint back up? Okay. Okay, great. And then John mentioned making a timeline, which is also a crucial thing to do. If you have a timeline of when events happen, you can start to see if there is a conflict between witnesses on when an event happened, which might be key. You can also just help everybody understand what happened in the case and what the big facts might be if you put them in sequential order. Because you're dealing with 6 affidavits and a number of exhibits that you then have to kind of collate together into one story. You're also going to want to figure out how to organize your team. In past years, I used a website called Wigio. That's W-I-G-G-I-O. It's a free group website where you can have a joint calendar, you can share folders, you can do editing right in it. It's a really good tool. The kids can get their own logons, the parents can have their logons, and it's totally free. So that's one tool to look at. Dropbox can work well in some places. Google Doc can work well. It just depends on what your kids and their families have access to, what they understand how to use. You can always go the very old school route of writing it out with paper and pencil or typing it in class and printing it and keeping it in the classroom. But then that's a lot more on you as the teacher, I think, to keep things updated, as opposed to when you can go to a computer lab, sit the kids down, and they can all work on their own stuff from a saved joint place. The next thing you'll want to do once you understand the case, you've outlined it, you've done a timeline, is you're going to want to start to brainstorm your themes, because as you're writing your parts, having a theme in mind, even if it doesn't become your final theme, is going to be very helpful to you in trying to figure out how to craft the case, what points you choose to use, what points you choose not to use. You know, something may sound really exciting, but when you look at your theme of the case, that fact suddenly doesn't make sense and isn't useful. And so if you have at least some idea of what that theme is going to be, you can be more organized and you can start to narrow down your facts a lot more quickly. And then how much time this takes, I mentioned earlier, you know, it's really what your kids want to put into it versus what their goals are. Another thing to consider is going to be, as you get closer to tournament time, are you going to up or down the time? And that's a decision that you as the coach have to make with the parents. If your kids are anything like mine, they wanted every evening of my life for the 2 weeks leading up to the tournament, and sometimes they got it and sometimes they didn't, depending on if I had the time to give and if their parents thought they were too stressed out. So that's, you know, the amount of time being put into it kind of has to evolve throughout the season as well, depending on your kids and your situation. So then the next point we had was John's required paperwork. So I don't know if we want to skip that. Okay. All right. So the next bullet point, well, actually, Van, do you have additional points on that stuff I just talked about before we go past it?
Yeah, just a few.
Okay, I'm going to turn it over to Van because he works with a teacher coach, so he's going to have a different perspective.
Hello, everyone. My name is Van Everett. I am an attorney here in Des Moines. I practice at Whitfield & Eddy, a medium-sized firm here in town. Like Christina, I've been involved with mock trial for a long time. I participated at both the middle school and high school levels here in Iowa, and at the college and law school levels. I've coached at the middle school and high school level for the past one or the other, if not both, for about 10 years now. So as Christina mentioned, I coach for a bigger school. For the last several years, I've been coaching for Johnston at the high school level, and there is a lot of institutional support at a big school like Johnston. There's some great educator coaches that will stay on top of the kids, make sure they're doing what they're supposed to be doing, making sure they're showing up to practices, and they also help coordinate when and where we can meet if I need that help. So a lot of the initial things, such as getting the teams together, is already done for me by the time I step in. I basically go in, ask the teacher coach, who am I coaching? They provide me a team, and then I start working with those kids. So a lot of that stuff's already done for me. I think that as far as navigating the role between attorney coach and educator coach or team parent, I've had a team parent helping me out for the last 2 years. Well, I did. My team just all graduated, so I'll have a new one. But I thought the team parent was really critical to running a smooth season. And I think if you can have a team parent, it will really help as you're coaching your team and moving throughout the season. And what my team parent really just did was schedule practices. And if you can even just take that load off of your main coach, whether your main coach is a parent or an attorney or both, that's a huge help. Because if the attorney coach or the main coach can really just focus on teaching the kids how to do mock trial, revising the kids' parts, and not have to worry so much about the logistics of, when are you all available to practice, it will be a big benefit to your team and a big help to the coach. Because I've coached without that logistical support before, and I've coached with that logistical support, and it is a huge help to have that logistical support. So as far as dividing duties, if there's one coach or a team parent or an educator coach that can handle, when are we practicing, that is great. And I echo all of Christina's comments about taking into consideration all the kids' schedules, all the coaches' schedules, the attorney coaches' work schedules. It's obviously very important. I also echo what Christina said about time commitment. That really has to depend on your kids because, like Christina said, if they want to do well and make a run at the state tournament or placing at state or even winning state, you got to practice 3 times a week, if not 4. If they want to have fun, have a good experience, you can get by with 1 or 2 practices a week. I totally agree with those comments. But that has to be something that the kids generate. As far as deciding parts, I approach it similarly to Christina, although kind of the first year that I work with a group of kids, if I don't know, who they are or what they're good at, what they want to do, I've never seen them in a mock trial round before, I will largely let them not necessarily assign their own parts, but I take their input and I just kind of follow it. I get, like Christina said, a list of the top 2, 3, 4 parts they would want to do, whether they want to be an attorney, whether they want to be a witness, and largely just kind of go with that. And the way I stick with the team until they graduate generally. So if I have experience with the kids, then I generally like to assign the parts because I think at the end of the day, it is helpful to the kids to not be totally accountable to each other for which parts they do, because that's a great way for feelings to get hurt, for kids to develop chips on their shoulder against their teammates, which is never something that you want. So even though you take the kids' opinion into account, I do think it's important the coach at least seemingly be the final decider of who gets what part, because you want the kids to just be taking the instructions from the coach, not bickering amongst themselves over who should give a closing argument, who should be the expert witness, this, that, and the other thing. I mean, try to do it as fairly as possible. And one of the ways that I do that is I always ask them to give me an honest evaluation of how much time they actually have to commit to mock trial. The kids that don't have enough time aren't going to have parts on both sides of the case, because it's not fair to the team and it's not fair to them for you to ask them to commit to parts on both sides, even if they really want it sometimes. If they really can't, if they just don't have the time, if they're involved in sports or choir or band or drama, some kids just don't have enough time to have parts on both sides of the case, and that's not a bad thing. They're still a valuable member of the team. But that's an easy way to divide up parts in a way that they will appreciate and will be fair. As far as the initial approach to the case, I handle that in a very similar way to the way that Christina does. The one thing I would emphasize is you want this to be as good of a learning experience for the students as possible. So to the extent you really want to make them do those steps, I mean, do them as a team and help them kind of check their work more or less. But when you're developing a theme, when you're going through a proof chart, going down the claims and figuring out which facts are good for which side of the case, which parts are going to need to bring out those facts during testimony and bring up those facts on opens and closes. You really want the kids to be going through that process of thinking about those things, because that's the whole purpose of this program, is to teach kids how to approach these types of problems in an analytical way. And I would just caution everybody to be careful not to do that work for the kids. You want them to be thinking about that for themselves, and of course offer your own input so that they can see, oh yeah, that's something I didn't see before. But sometimes you'll see coaches that will do everything for the kids, and it can be tempting if they're struggling sometimes, but I would just really caution everybody to make sure that they are having the kids do the bulk of that work, and then you help them revise that work after they've done it. And with that, I don't have anything really too different than what Christina had. I think that's in general a good way to approach setting up the case, doing scheduling, assigning roles, a pretty good estimate of how much time things take in general. As far as scheduling goes, the one last comment I would have is if you do have a team with a bunch of busy kids that are involved in a bunch of different activities, what I've done in the past few years, and I've found to be particularly effective, is if you really just can't have everybody there multiple nights a week, don't try. I mean, have at least one practice a week where the whole team is there, and then we would have one practice where we would focus more on the plaintiff or prosecution side of the case, and then a third practice where we would focus more on the defense side of the case. You don't necessarily have to break it down that way, but just as long as you know which kids are going to be at which practices, even if they don't show up for every single practice every single week, you can just make sure that when they are there, you have time to run their parts or work on their parts, and then when they're not there, you're not, for example, if you know that an attorney's not going to be there who directs a certain witness, then maybe that witness doesn't need to be there either. So you don't have kids sitting around at practice with nothing to do, distracting the other kids, making it difficult to have a productive practice. So certainly be cognizant of that when you're scheduling which kids are going to be at which practices, if you can't find more than one night a week where everyone can be there, because frankly, it's difficult to do when you've got 10 gifted kids on the same team. So yeah, with that, we're going to go to our next topic.
I'm shorter than Van, so Christy will have to come back and adjust the camera again. Okay. Van actually brought up a couple of follow-up points that I'm just going to hit real quick because I think they would be useful for you guys. When he was talking about parents, mind their skills. I have a parent who's a graphic designer. That's actually my coaching parent. She does all my demonstratives for me, and they're beautiful. I've had parents organize snack schedules. I've had parents volunteer to drive to scrimmages. We have a scrimmage arrangement with Muscatine on the other side of the state, which, by the way, is great as well if you have someone outside your region, because you can share ideas much more freely because you're not going to hit them at tournament. I've had parents take charge of organizing the meeting space for me. So figure out what your parents can do and then get them involved, and that takes the load off of you, and if you have an attorney coach, off that person as well. Don't be afraid to waste time on team building. A lot of people just want to hammer on the drafts and that kind of thing. But if these kids don't like each other, they don't trust each other, they're going to interrupt each other in tournament, they're going to talk over each other, they're going to get mad when somebody's not taking their advice. So the more you can build the team, the more you can do fun stuff together, the more you can make them like each other as much as you can when you have so many strong personalities on a lot of these teams, the better they're going to function in trial. So don't see that as a waste of time. And then help them set expectations. Sixth graders are probably not going to win the tournament. There have been sixth graders in the semifinals, but they were from established teams in established programs and put in a lot of time. So don't let them get freaked out if they go see like an eighth grade team and they're like, well, we might as well quit now because, oh, well, we're done. No, talk to them about what does it take to be that team in 3 years. And then breaking down practices by kids, his last point, I've done that as well. And what I just tell my kids is if this is your night where you're scheduled for practice, you are my priority. If you have time to come that night and you're not on the scheduled list, that's great. You're welcome to come. But you go behind the line for everybody else when you're all clamoring for my time. And that's usually worked pretty well. So The next main topic is resources for learning the rules of evidence and procedure. The first is going to be the mock trial guide that's on the website. That's been around for a number of years. It's a good basic guide to get you started. So if you have not looked at that already, pull it up off the ISBA website. You know, if you can't find it, John can help you find it. But it's right there on the mock trial website. It should be pretty easy to find. There is a lawyer named McElhaney, and that's McElhaney. Almost anything he's written is going to be fantastic. He writes in a really witty style. He writes them as articles often. So if you're looking for explanation on a topic of evidence or procedure, I would check out his books. Lawyers go to those books all the time. Some things that I do with my team to work on evidence procedure, the number one thing is what we call litanies, which is just, you know, when we enter a piece of evidence, what do we have to say every time we do that? If I'm establishing an expert, what are the questions I have to ask every time I do that? And you write it out, you list it out, and then you pick names out of a hat and you make them do it. It takes a lot of time. You have to start by letting them use notes, but eventually you reach a point where you say, okay, enter a photograph, and they've just got to stand up and do it. So that drilling can be really useful. A couple of things that I kind of invented and used with my kids that they've always really enjoyed. One is, we call it the evidence ball. It's literally like a playground ball that I've taken a Sharpie marker and I've written on it evidence and procedure rules, and when they were younger, I did much simpler things. So when they were younger, it was things like, what do you do when a judge enters the room? How do you address a judge? The basics of objections, like what is hearsay, what is relevance. So we started very simple, and you just throw it around the circle, and when they catch it, whatever their right thumb is on, they have to answer that question. Now that they are going to be sophomores in high school, their ball is entirely rule numbers. That's all that's on it. They hit a number and they've got to tell me what that rule is and what it means. But with sixth graders, you can start much simpler, and you can just give them a lot of the basics on there, and it's kind of a fun way to, again, drill something that would be very boring just going over it over and over and over again. I also invented an improv game called Who's My Witness, where one of them is an attorney, one of them is a witness given some sort of goofy character, and that attorney has to just direct examine that witness until they figure out who it is. So you start to work with them on what style of questions do we use on a direct? How do we follow up a train of thought? How do we get to who this person is? And so those are a couple of things I've used. If you have questions about either of those ideas and want to use them, I'm always happy to talk about them. So Van, John, do you guys have any other resources that are good?
Yeah, so just to add a couple other resources as far as rules of evidence go, there's a book that is a more formal book of trial objections. It's called The Objections at Trial, very creative name. The 7th edition is the most recent one, and that has it's like a pocket-sized book. It has all the different trial objections. When you look through it, you want to make sure to compare it with the mock trial rules of evidence, because there will, of course, be some of the rules that are covered in that book that we don't use at the middle school or high school mock trial level here in Iowa, but there'll be a lot of crossover. So that's a good resource. Also, as far as resources that are easily accessible to the students, there are actually some pretty fun videos on YouTube. They're like hearsay exception videos with little Lego people and like goofy little songs. It'll seem a little childish, but they're actually really good resources, and we even used them at the college level when I was there to help teach hearsay to people who had not previously been involved in mock trial, because it can be a tricky rule to learn even for practicing attorneys or law students, let alone middle schoolers. So that's a pretty good and more fun resource, more accessible to kids. And the last one, I don't know if it still exists. I honestly haven't searched for it in a while, but there used to be online a rules of evidence computer game, that streaming computer game where you'd basically, the kids would, there'd be different levels with different examinations that were going on, and then an objection would be made, and the kids would have to click on what the right option was for that particular objection, given that particular testimony that had been elicited in that level of the game. And it's just another way of instituting a drill, like Christina was talking about, that really helps the students, you know, work over and over again with the same rules so they can apply them more easily to different situations that will come up during trial. That was a pretty good resource. We also used that one even at the college level with a lot of success, honestly. And the one last thing I would say about, you know, you can obviously, Christina has developed some really good drills to use. We use similar drills on my teams, you know, just opportunities for the kids to work with the rules of evidence. I set aside the first 15 minutes of every practice to just do rules of evidence stuff, because it's really important, even if you don't end up making that many objections during trial. One, you'll run into teams that will, and kids need to be able to know how to respond to those evidentiary objections. And two, for my money's worth, there's no easier way to impress an attorney judge than to just nail a rules of evidence response, because there are so many practicing attorneys, and judges say this every year, and it kind of sounds bogus when they say it, but it's really true. There are so many practicing attorneys that don't know the rules of evidence well. There are judges that sit on the bench that don't know the rules of evidence particularly well when compared with people that have done mock trial for more than 2 or 3 years. So to have a middle school student stand up and nail a hearsay exception response when there are partners at my firm that wouldn't be able to articulate a hearsay response that well, is just going to be extremely impressive to any coach or judge, excuse me, that is going to be judging your students. So, you know, you don't want to spend all of your practice time on rules of evidence stuff, obviously, but I do think it's important to carve out some time to do rules of evidence reviews. And to the extent that you can make those drills focus on the kids understanding and applying the rule even in an abstract way is going to be even better, because there are going to be teams and students that show up on competition day and use the rules incorrectly. And in order for the students to really be able to understand what's happening and explain why the other team and the other students are using the rule incorrectly to the judge, they really have to understand why that rule of evidence exists, what the purpose of it is, and why whatever the explanation that the other team, the other students gave for that rule is incorrect. They really need to understand that at a pretty deep level. And it might not be something that is achieved in the first or even second year of participating in mock trial, but you want to lay the groundwork so that if the students do continue on in mock trial, they can get to a point where they really have that kind of deep understanding of what the rule is and means, and that way be able to explain on the fly whatever the situation is in which that rule comes up during a trial. So whatever drills or rules of evidence review you institute on your teams, the focus, in my opinion, should be on them understanding and applying the rule, not necessarily just reciting it, although there is certainly room for them just reciting it, because you need to be able to do that as well. Next point we're going to talk about, and I'll just start on this one so we don't have to keep readjusting the camera as often, is resources for crafting good witnesses. I'll start with this one because, frankly, I don't have a ton to say on this point. Witnesses have never necessarily been my specialty. I can get witnesses to a certain point, and then after that I need assistance to get the witnesses to go from being good to really great. The one thing I would say for witnesses is, when you're teaching your students how to be effective mock trial witnesses, the emphasis should really be on being true to that witness's character and not necessarily being overly aggressive for that witness's side of the case. And what I mean by that is, you know, if you've got, you know, the defendant, for example, in this case, the one being sued, obviously has a stake in the case, because if that character were to lose that case, they have to pay a bunch of money to the plaintiff. So it makes sense for that character to be very passionate and defensive, even on cross-examination, because they have a personal vested interest in the case. There will be witnesses on both sides of the case that don't have that kind of investment in whatever the outcome of the case is. But often what is the initial impression of the student is, oh, I want to help my team, so I'm going to get really defensive, I'm going to argue really hard for whatever the side of the case I'm a witness on. And that's not always what that witness should be doing. If there's an impartial, witness who's just there to testify to what they saw, there's no need for that witness to get worked up at trial if they get hit with a hard cross-examination about what it is they saw. On the one hand, they still want to be firm about, no, this is what I saw, this is what I remember, but you don't want to get worked up and have that witness be taking it personally and get overly defensive, because then it looks like a kid playing a character instead of the kid just being that character and exuding who that witness is. And the earlier that kids learn that and appreciate that, the better they're going to be as witnesses, the more convincing their witness parts are going to come off to scoring judges who may or may not have even read the case. But I've talked with many people who have judged mock trial only a handful of times, and frequent feedback I get is sometimes they're confused as to why certain witnesses got so caught up in the case, and it's because kids are so want to help their team that, and sometimes they sacrifice that character, being true to that character, in order to try and help their team. And while obviously you want them to be thinking, how do I help the team, they do that by being true to the character instead of selling out for one side of the case or the other. As far as resources for helping craft good witnesses and get the kids to do a good job as far as technical aspects of being a witness, when the teams that I competed on, our best witnesses were always people that were involved in drama and had drama skills. One of our best witnesses on my high school team year in and year out is now a professional actor in LA. I mean, he's very good, and he always was, even back in high school. So to that end, if you're looking for resources to help with that, anybody with a drama background is going to help kid be a good witness, because at the end of the day, they're trying to sell a certain character. It's very much like acting to a certain extent, just with a little more thinking on your feet than just remembering a script, as far as like a scripted play would go. So any kind of drama resources are generally going to be good as far as helping kids get into a role, really sink their teeth into a witness role and bring some of their own character to that witness. Those resources will be helpful as far as crafting good witnesses. Christina, you want to weigh in?
Okay, I do have a few more thoughts on good witnesses. I actually have an undergrad degree in theater, so I get a little hyper about witnesses, actually. Van has pointed out my number one pet peeve, which is when a witness gives up being a witness to fight for their team. The other thing a lot of witnesses do is they throw a whole bunch of energy at it, and it doesn't fit. They're supposed to be the cranky old man, but they're answering every question like this. It doesn't read very well. You can tell they're very involved, you can tell they're very excited, but it's not really playing that role. So the first thing is absolutely to talk to them about, how do we make this a believable witness? If you have access to someone in your community who does theater, whether it's a college professor, a high school teacher, someone who's heavily involved in your community theater, and they're willing to come in and workshop with your kids, do improv games, talk to them about what makes a good character, those kind of people can be fantastic resources. You might have a parent who does some of that and might be willing to do something with your kids. I have found that improv exercises are huge in helping both attorneys and witnesses learn to think on their feet, learn to be in character, and stay in character no matter what happens. So if you have someone who can work through improv exercises with them, or you can go to your local library, there are tons and tons of books out there that have improv exercises. Anything published by Second City is going to be good. They have made a lot of the SNL actors over the last 40 years. So anything by Second City will be useful to you. Do those exercises. It's fun for the kids, it builds the team, and it works on these skills. When you're thinking about witnesses, they should have energy. And by energy, I don't mean like super excited. I mean exuding energy and interest in what they're doing, but not necessarily being hyper or excited or something like that. And good witnesses always have peaks and valleys. So if your witness is an angry witness, if they're angry from the moment they get on the stand to when they leave, that's okay, but it's not as good as if there's some point where they suddenly start chuckling, or they soften up, or they start to cry, or you see some other dimension. People are not one-dimensional, and mock trial witnesses shouldn't be either. One of the common mistakes I see is that when you have the victim witness or the crying witness, they're just crying nonstop from the minute they get up there. That's not realistic. I mean, people try and hold it together. When they're talking about, the things they like to do, they're not going to be bawling. They're going to bawl when they start to talk about their dead child, or whatever the case might be about. So talk to your kids about peaks and valleys, right? Like, when do we have high emotion and when are we more stable? Because then when you bring out the tears and the histrionics, if you have a really good crying kid, it has a lot more impact, and you're going to scare the other team if all of a sudden you start crying on cross. So peaks and valleys, and thinking about how do you make this person multidimensional is going to help a lot, and that's something you can talk about with them even if you don't necessarily have theater training or a theater background. One other suggestion I have is that once you have your directs and crosses written, change it up. So don't always have the same attorney directing or crossing them, particularly crossing. Because a lot of times they get used to their teammate crossing them, especially if they're new, and they freeze up when they get to tournament, and suddenly it's somebody on the other team crossing them. So have other people on your team take a shot at it, just to help them be a little more flexible. And just really look for, there are a lot of great books out there. A theater person in your area might be able to point you to some, or just go spend a couple hours at the library looking through them and find some that have activities that look fun, that you think might help with what your kids are doing. Anything around character building and around improv is probably going to be the best area to shoot for with that. We had a few initial questions that were sent in to us by email that kind of feed into a lot of the things we've been talking about. So I'm going to address those really quickly. An additional resource on working with responding to objections would be to get DVDs of past state tournaments. They're available through MediaCom, I believe. Is that right, John? Okay. They're available through MediaCom. You can also get your hands on national collegiate final rounds. Those are impressive rounds. So if the kids are really just struggling with what does this look like because they've never seen a round, get a DVD and just let them watch a round of a previous case, and it'll suddenly click. Scrimmaging with another team will also make it click. It's one thing to watch it, it's another to do it. So if you can get your kids together with another team and scrimmage before the tournament, they're going to be a lot less stressed out at tournament time. Let's see, I'm skimming the other questions here very quick. Good video resources for learning about civil cases and jury instructions. We don't have any materials specific to the jury instructions in this case, but lawyers use a book called Black's Law Dictionary a lot if we're looking for a definition of a term. So if there's a term you're struggling with, you could go look at Black's, and it might have some other ways of explaining it. And reach out to an attorney in your area, because even if somebody's not willing to coach your team, they might be willing to sit down with you over coffee and go over the jury instructions and help you get a better idea on them. They might be willing to come in and workshop with your kids about what they need. They might be willing to just take a look at a closing argument and give you some pointers. You might be able to get people to kind of piecemeal give you some help, even if they're not willing to coach. And sometimes that's a much easier ask of someone who's very busy, is to say, do you have an hour? Can you do this one thing for us? And so if you're struggling to find an attorney coach, see if you can get some different perspectives and get just pieces of information from attorneys. It's not as helpful as having a comprehensive eye on the case, but it would help you get some guidance on what these things mean and how to process through them. And I think that is the end of the issues I had. I think we're on to John Landy to go over how a mock trial round actually occurs.
Good afternoon and good evening. Thank you very much for the time that you're taking to learn a little bit more about mock trial. My name is John Landy. I'm an attorney here in Des Moines. Like Van and Christina, I started doing mock trial when I was in 7th grade. I did it in high school, college, and law school, and am now a practicing attorney. And so I want to just take a moment and thank those of you who are participating this evening for the time and effort that you're going to put in. For some of your students, this may really be a career path for them that they decide to embark upon. I want to continue on with the theme that Christina and Van have been following, and that is how to make this as easy for you, particularly as first-time educators who are learning for the first time how to run a mock trial team. One of the resources that Van had mentioned was a small book. It's actually published by the National Institute for Trial Advocates. It's a book that I still routinely use in my practice, and I would encourage you, if you're having trouble learning objections or being able to explain objections in a way that makes sense to your students, to rely upon a resource like that. I'm going to talk primarily now about the flow of a mock trial round. For those of you who have not yet been through a mock trial round, it's good to have a little bit of an understanding of exactly what you're getting into. The first part of a trial is begins with the pretrial conference. What will happen is the students will have some time before the round starts to get the room set up. They'll come in, they'll see one side of the room is for them. They'll have a table where the attorneys will sit, and there'll be a row of chairs behind them for witnesses. They will set up, the attorneys will sit at the table, the witnesses will sit behind them, they will get all their exhibits out, and they'll just wait for the judges. When the judges come in, everyone will be expected to stand in recognition of the judges entering the room. The judges will take their seats at the front and tell everyone to sit down. And so we'll begin the pretrial conference. There are a number of things that are covered during the pretrial conference, and depending upon who your judges are, they may have ideas about what they want your students to cover. Just to give you kind of a rough summary, and I know John Wheeler has put out some resources that cover what occurs in the pretrial conference, but probably what will occur is the students will have binders that have exhibits, the affidavits, perhaps jury instructions as well in them that they will present to the judges who are going to be in that round. Frequently, an attorney from your team who's doing the pretrial conference will want to ask about the judge's preferences for moving around the courtroom. Depending upon the site where your round is located, there may not be a lot of room for people to move around outside the area directly adjacent to your table. But some judges may have a strong feeling about whether or not it's appropriate for your attorneys to be moving in what's called the well of the courtroom, which is the area between the place where the judges are sitting, the witness stand, and then the two attorney tables. And so you want to teach your students to ask the judges for those preferences. You want to teach them to ask what the judge's preference is about approaching witnesses, if attorneys will need to ask permission before they do that. You'll want to address any demonstrative aids that are going to be used during the course of the trial. For example, if you have enlargements, it is generally a good idea to have already shown those to the other side so that you avoid any surprises during the pretrial conference. Typically, the judges won't care too much unless there's an objection by one side. So it's a good idea to just get those cleared by the other team in your round ahead of time. It's also an appropriate time for students to introduce themselves, not only the attorney who's doing the pretrial conference, but also the other students at the table and the students who will be portraying witnesses during that round. It's also a good idea for the students and anybody who's come to watch them to make sure their cell phones are off at that point. The last thing anybody would want would be to have a phone ring during the middle of the trial. In all likelihood, if you are the plaintiff or the plaintiff attorney, you'll want to address the issue of rebuttal during closing argument and mention to the judges that you intend to use any time remaining at the end of the closing argument for rebuttal. If you're a defense team in your very first round, if you've never done this before, you will hear the plaintiff attorney probably ask for that. It's a good idea to just do that during pretrial so you avoid any disputes later in the trial about whether or not that was requested. A couple of tips right before we get into the substance of what the round is, all contact during a round, once a round has started, between the team and the coaches is prohibited. That goes for parents as well. It can be particularly challenging with middle school students when they're portraying or participating in their first round. Parents may want to come up during a break and congratulate them, and inevitably what happens is a member of the other team comes racing back into the courtroom screaming to the judges that there's been a rule violation. And for first-time participants, that can seem like an odd rule, and it's just something that you should be aware of, that kind of contact during the round is prohibited. Once the round actually starts after the pretrial conference, it'll begin with opening statements from both the plaintiff and the defendant. There are time limits on each of those, so the students will have a brief period to present their summary of what they think the case is about. After that, the plaintiff will begin by presenting the plaintiff's evidence, which will consist of calling the first witness. The plaintiff attorney will have an opportunity to examine the plaintiff witness, which is known as the direct examination. That will be followed by a defense attorney who has the opportunity to cross-examine that same witness. And that will occur for each of the witnesses on the plaintiff's side. And then typically what happens is the judges will have a short break before the defense calls its first witness. That break could be 5 to 10 minutes. It's a good opportunity for the students to collect their thoughts and get ready for the second half of the case, but of course not to go and talk to their parents or coaches. After the break, the defense attorney will call the first defense witness. They will have an opportunity to ask questions of that witness, and then the plaintiff's attorney will have an opportunity to ask questions doing a cross-examination. You'll do that for each of the 3 defense witnesses. After that, depending upon who your judge is, you may have another break before closing arguments. It's typically a good idea if the judge asks to ask for a break, so that if your team is using any large enlargements or demonstratives of any kind, you have an opportunity to set those up without the high pressure of everybody watching as you try to manage an easel into place. After the closing arguments are done from the plaintiff, the defense will have an opportunity for closing, and then after the defense is done, there'll be a rebuttal with whatever time is left for the plaintiff to get up and offer their final thoughts. Once the round is done, the judges will take a few moments to finish scoring. Once they've completed their ballots, they will give those ballots to a timekeeper, one of the students from each team who's been responsible for keeping time, and they can take those ballots then to the tab room. That procedure may vary depending upon where your round is, but expect that the judges will take a few moments once the round concludes to finish tallying their ballot. And it's important, particularly for middle school students, to understand that even though the round may be over, their demeanor and decorum still matters, and this isn't an opportunity to take the jacket off and start running around. The judges will be evaluating the students during the course of the round on a scale from 1 to 10, 1 being the least effective and 10 being the most effective. And in a few minutes here, Van Everett's going to get back up here and talk to you about how to use some of these scoring criteria as a way of teaching your students the kinds of effective roles that you're going to want them to perform, and what really make this a valuable teaching tool. The criteria that are used by judges are really intended to reflect what is considered to be effective in actual courtroom practice, and therefore we're trying to teach students how to be effective communicators, ultimately rewarding those who are capable of doing that a little bit better than others. In addition to a written score, all the students should receive written comments that try to explain and justify that score. At the end of the day, whenever I'm instructing judges on scoring criteria, I try to make them understand that this is an educational activity and that they should be providing feedback to students to explain exactly why they provided a particular score. With that, I am going to turn it back over to my colleague, Van, who is going to go through the how to use the scoring criteria for effective teaching of roles. So thank you very much.
All right, so I'm going to go through these relatively quickly so we can make sure we get through our whole outline of topics to cover today. Now, it's important as coaches to review the scoring guidelines, and I believe they're on the website, right? In the same place where you can find, like the rules of evidence, the problem, the case updates. You'll be able to find the scoring rubric because, and this will seem fairly obvious, but obviously understanding how the students are going to be evaluated at competition gives them a better chance to prepare in such a way as to achieve a higher score. One criteria you will see across all different parts, witness, attorney, open, close, direct, cross, is the use of notes. It's something that comes up every year, and whether you agree with it or not, the kids are going to be evaluated on whether they use notes. If they use notes, they're not going to be able to get the higher scores, the 9s or the 10s, if they rely on notes at any time during their presentation. And that's something they should know up front. I know there are some coaches there's one coach in particular who, when she coaches her teams, will never ever, throughout the entire process of preparing for the tournament, let them use notes at all. They always have to do all of their parts without notes during every single practice of the year. That's not the way I do it, but she's had very successful teams over the years, and that's certainly one way you can do it if you feel like that's appropriate. I generally have my kids write out their parts because then I can give them a redlined version of their parts back so they can see where I suggested some changes, not required the changes, but my suggestions, so they can kind of learn how to write more effective directs, crosses, opens, and closes. And I think it's valuable for the students to get that feedback, but students need to understand that by the time competition rolls around, if they use notes during the rounds, they are going to lose some points on their score. So they'll want to prepare in such a way as they don't need to rely on their notes. I would encourage against having kids simply memorize their written work, because during a trial, things are going to happen that are unexpected. Maybe an objection gets sustained that you didn't anticipate. Maybe a witness on cross-examination gave an answer you didn't anticipate. Maybe for a closing argument, a piece of evidence you thought would get into evidence didn't get into evidence, or something that a witness was supposed to say they forgot to say. So adjustments will need to be made on the fly, and that's tough to do if the kid is simply reciting a memorized speech or reciting memorized questions off of what they had written on paper. Instead, and kids, in my opinion, rarely actually need their notes by the time they get to a competition. They've been working with the problem enough, and they're bright enough kids, that they can generally do their parts without the use of notes. Just off the top of their head, reacting to the situation. What they need is the confidence boost to be able to do that. And so with at least a few weeks before the tournament, you need to pull the rug out from under them, essentially, throw them in the lake to teach them how to swim, and make them do their parts without the notes at some point prior to the tournament, because they can do it. They just need to realize that they can do it before the tournament hits. So without further ado, I'm not going to talk about the notes anymore. I'm going to go through part by part. How do I change the slide here? The arrow keys. Oh yeah, there we go. Oops. Okay, so sorry about that. Opening statements. With the opening statement, the biggest thing that you want to accomplish in a 4-minute opening statement is just telling the story of the case. This is extremely important, not only for the student's score who's given the opening statement, but also to set up the rest of your team to succeed. A lot of the judges that you'll have on the day of competition will not have read the problem prior to coming to the trial. They will not be nearly as familiar with the case as you or your students. And so in those 4 minutes, the most important thing that the person giving the opening statement can accomplish is explaining the case in a simple enough way that somebody who has not read the problem understands what's going to happen for the next 2.5 hours of their lives as they sit here and watch this trial. That is far more important than including anything about any type of argument about, this is what the evidence will show, this is how we're going to do it. Telling them what this case is about is the most important thing the opener can do. The other important thing is for the opener to shed some light on what his or her team's theory and theme of the case will be, and those are largely intertwined. I mean, theory and theme go hand in hand. And that you can weave directly into the story of the case. You know, this is a case about someone who was wrongfully accused. You know, that can be your theme in and of itself, and if that's the first words out of the opener's mouths, all the better. Oftentimes, I like to have my openers start with the theme as the first words out of their mouth, because it puts the judges on notice as to what your theory, what your theme of the case is, and they will understand your position all the better moving forward with the case. So the opener wants to be able to clearly explain what the case theory and theme is while also telling the story of the case. And then toward the end of the open, you do certainly want to introduce which witnesses are going to come up, what they're going to say, why what they're going to say is important to the case. Obviously, this has to be pretty concise, all of these things, because the opening statement's only 4 minutes, and that goes by extremely quickly when you're trying to synthesize a complicated mock trial case. So being short and to the point is going to score you points on the open. Moving ahead to direct examinations. For a directing attorney, this can be both one of the easiest and one of the most difficult roles, in my opinion, because if you're doing it well, the judge shouldn't notice that you're there. You want the focus to be on the witness, even to the point where the kids want to position themselves in a position in the courtroom so that the judges have to direct their attention to the witness instead of looking at the attorney the whole time. The questions should be short, they should be pretty direct, and they should be open-ended so that the witness can talk as long as they want without technically being non-responsive to the question. The way that I explain this to my students is there's 3 types of questions that an attorney can ask. An open-ended question, which begins with what, where, why, when, who, how. A leading question, which implies its own answer, which they want to do for cross, such as, you went to the train station at 8 p.m., didn't you? Where it implies its own answer. And there's closed-ended questions, which are questions that start with verbs. Did you go to the mall yesterday? Did you eat lunch today? Those types of questions. It's very tempting for kids to use closed-ended questions on direct because it easily elicits the answer that they want without technically, in my opinion, being a leading question. But they aren't the most effective direct examination questions. You really want to push the students to come up with open-ended questions for direct examination to entice the witness to do all the talking rather than these short questions that elicit short answers and then put the focus right back on the directing attorney. And obviously, you want to be able to enter exhibits into evidence with proficiency and respond to objections with proficiency. That'll go for cross-examination as well. But for direct, you want to ask questions in a way that put the focus on the witness, position yourself in the courtroom in a way that will focus on the witness, obviously not use notes, and you want to tell, the questions want to be ordered in such a way that the witness can tell their story in a way that's going to make sense to somebody that's not familiar with the case material. Typically, chronologically works best, but sometimes it's easier to go through them topically, like if you have an expert witness and the expert witness has 3 or 4 different opinions or one opinion with 3 or 4 sub-opinions, going through opinion by opinion can be more effective there. So that's direct examination. Cross-examination, exactly opposite from direct. You want it to be all about the attorney. You want to position themselves in a courtroom where the judge has to see the attorney anytime they're looking at the witness. These questions you want to be leading. You went to the train station at 8 p.m. last night, didn't you? You don't want the witness to be able to answer the question with any type of additional information without necessarily being non-responsive to the question, since all the questions will be yes or no answers. A great resource that's out there for cross-examination, because it is one of the hardest things that kids will have to do during a trial. There's a video by a former law professor named Irving Younger called the 10 Commandments of Cross-Examination. It's used in law schools all the time. It's highly entertaining and it's extremely helpful in teaching students at any level, middle school all the way through law school, what to do and what not to do during cross-examination. It's about an hour long. It'd be great use of a practice or half of a practice to watch the video. I'm not exactly sure where you can find it. You can probably Google it and find it somewhere. But yeah, with cross leading questions, and having the attorney be in control of the entire cross-examination. The other thing with cross is you want to kind of get in and get out. You don't necessarily want marathon cross-examinations. There are certain witnesses where cross will necessarily need to be longer, but generally, if you make 2 or 3 clear points on cross-examination, have 2 or 3 pockets of questions. You know, for example, if they're crossing an expert witness, having one pocket be, exploring their bias. You got paid this much to give an opinion, didn't you? You testify on behalf of defendants all the time, don't you? In fact, you've only testified on behalf of defendants, isn't that right? You're testifying on behalf of the defendant in this case, is that correct? And they're paying you $500 an hour for your opinion today. That's a great pocket of cross-examination for a question or for an expert witness. And then you could move on to attacking, one part of their expert opinion and then another part of their expert opinion, and boom, done, sit down. That's a great cross-examination. Moving on to witnesses. Christina and I kind of already talked about this earlier, but they're going to be evaluated on how well they get into and stay into character. And that's both, the emotional notes they hit, like Christina talked about earlier, which was a great point, and also just about how they respond to questions. Witnesses who should get defensive, and witnesses who don't necessarily have a stake in the case should not get as defensive. The witnesses want to be able to tell a story, but not do it in a way that seems contrived. I mean, you really want, when witnesses are kind of preparing their answers, you want them listening to the question that's asked and answering in a way that actually answers that question. Because if this is a real witness in a real life trial and I'm examining a witness and I ask them what they did today, most witnesses are not going to start with they're not going to give me a minute by minute detailed description of every single thing they did that day, but sometimes mock trial students are tempted to do that because they know that that's ultimately what the attorney wants, but you don't want to necessarily go so outside of your character and go into being an advocate for your team mode that you give up what that character is. So they want to tell a story, but in a way that is authentic to that character that they're portraying. Eye contact with the judges is a big scoring point for the witnesses. They want to make direct eye contact with the judges as much as possible and vocally deliver their answers in a way that's persuasive and shows confidence in what they're saying. Also, knowing their statement cold is a must for witnesses. They really need to reread that statement. And it can be tempting to not reread the statement. John and I were actually on a law school team that made it very far in one of the national tournaments held by at the law school level. And it was a simple car accident case. And we had gone through the whole season thinking that one of the witnesses' affidavits mentioned a stop sign. We reviewed it before I think it was the semifinal round of the national competition, and discovered that there was no stop sign. We had at some point in time made that up and totally overlooked it because we hadn't reread the statements in a long time. I bring this up because it's really easy to, after you've been working with the case for 4, 5, 6 weeks, to kind of fall asleep on the fact that you might not remember every single thing that's in that statement. You've been working for it for so long that you feel confident that you do, but it's always worthwhile to have witnesses reread their statements. If they're not doing anything else during practice, it is never a bad decision to just have that witness reread their statement again and see what's in there. You'll be surprised at how much you forget from week 2 to week 6, even though you've been working with the case consistently during that time period. And then not getting rattled, that goes hand in hand with knowing their statement. If they know the statement and they are confident about what's in there, they're not going to get rattled, because sometimes attorneys will, pretend like they're going to impeach the witness, pick up a legal pad, be like, are you sure you said this? If the witness knows what's in their statement, they're not going to get rattled by that stuff. So the more they've read the statement, the more comfortable they are with the contents of that statement, the less likely they are to get rattled. Closing arguments, completely different from the opening statement. This is where you want to be making the arguments. The way I look at it is, with direct and cross examinations, those are a volleyball match, those are the setters. They want to set the ball up so that the closing argument can come in and spike it down on the other team's side. You don't necessarily need to be making arguments, making the points completely in direct and cross examination. You just want to get out enough information so that the closing argument can come in and say, Now on so-and-so's direct examination, you heard him say this. And on so-and-so's cross-examination, you heard her say this. That's because this. And it connect it to whatever element of the case that connects to the closing argument, explains how all the information that the judges have heard throughout the trial are actually important to the elements of the claim or the case that are involved in that case. That is really what the closing argument needs to do with proficiency to score well. You don't just want to summarize the evidence. That's very tempting for students to do. You heard this witness say this, you heard this witness say this, you heard witness say this. Thank you, nothing further, Your Honor. It's not bad, but it's not as effective as the closing argument can be. You really want to take the summary of the testimony and turn it into argument as to why the judge should rule in their favor. The closing argument, whoever's delivering your closing needs to make sure they're paying attention to every single part during a trial, because you never know when a witness is going to forget to say something that they were planning on using in their close, or evidence just doesn't come in quite the way that they thought, and they need to adjust the way that they deliver their closing argument to make sure that it actually is in line with the testimony as it came in that particular trial. You can plan for it to come in one way, but it might come in a different way. And if the closer delivers their closing in a way that is consistent with the way the evidence actually came in, they're going to score much higher. It's right in the scoring guidelines for closing argument. If you're doing plaintiff's closing, make sure you ask for rebuttal. John is absolutely correct. You should ask for it in pretrial conference. I would also recommend reminding the judge, having your student remind the judge before he or she begins the plaintiff's closing argument, say, Your Honor, I just want to confirm I've reserved all remaining time in my closing argument for rebuttal, just so that the judge doesn't forget it in case they didn't make a note about it, because that can happen. And then you want to make sure at the end of the closing argument they specifically ask for the judge to rule in their favor, either enter judgment in their favor if they're the plaintiff, or enter a ruling in the defense's favor if they're the defense. And I didn't mention this earlier, but when the closer is arguing about how the evidence was presented helps either proves or disproves their case, they have to mention the burden of proof. If they're the plaintiff, they bear it. They need to acknowledge that they bear it and explain why they've met it. If it's the defense, they have to point out that the plaintiff is the only one that bears the burden of proof, and here's why they didn't meet it, or here's why they failed to meet it. Love the word failed in a defense closing argument. It's great. And then just overall, well, no, that's not really on the rubric. But so yeah, you can get a lot of tips in helping the students prepare their parts by looking at the rubric by which they're evaluated and making sure that they are preparing their parts in a way that complies with those rubrics for every single part of the case. What's next?
Looks like it's cooperation between attorney coaches and teacher coaches.
Okay, yeah. So yeah, the next thing on our agenda, which I'll address briefly, is, I already touched on this a little bit, cooperation between attorney and teacher coaches. In my experience, it's been very helpful if one coach or another, it doesn't really matter who it is, just kind of whoever's better at it, runs the logistical aspects of setting up the team practices, setting up the team schedule. It's really helpful if just one person focuses on that and the other person can focus completely on helping the parts, which is not to say that whoever's helping with logistics doesn't also help with parts. But if you know that one coach is in charge of logistics, it makes it a lot easier to run a smooth practice. I've also found that my teacher coaches are really helpful if I'm having a student who's struggling. It's really helpful for me to be able to use that teacher coach as a resource to help kind of get through to the student and figure out what the problem is so that we can address it together. The teacher coaches, in most cases, at least for me, has known the student for a lot longer than I have, and has in most cases been teaching the student for some time, and they have a longer connection with the student than I have, at least if it's my first or even second year coaching that particular team, that particular student. So if I notice that one kid is kind of falling further behind the rest of the kids in his or her parts, it's really helpful for me to be able to contact the teacher coach and say, hey, could you have a talk with so-and-so. I think he or she is really struggling with this, that, or the other thing. And that can be a really useful way to work together as the teacher and attorney coach. But beyond that, I would just kind of reiterate what I said earlier. I mean, teacher coaches are extremely helpful, and having that kind of logistical support makes my job a lot easier as an attorney coach. So, Christina, do you have anything else you wanted to add on that?
Not on that. I do have a couple of thoughts on the last couple of sections. So
Sure.
before we go on the sticky wickets. And Christy, I'll just go up on tiptoe maybe, so you don't have, because I won't be up here terribly long. Just a couple of additional thoughts on the subjects that John and Van went over. John mentioned the kids being out in the well and that the judge might have a preference. Do be aware that in mock trial the standard is for the kids to be in the well. So you may get a judge who's used to what we call a sitting jurisdiction, where they do everything from their chair, they miss the judge's briefing, they fall asleep during the judge's briefing, and they tell you that the kids have to do it from sitting. So work with your kids on the fact that it's rare, but that can happen, and they should follow the judge's expectation on that, because it's going to affect their scores if they don't. But generally the expectation is for them to be in the well, doing this on their feet, and so that's really how you want them to practice. Teams need to get a trial notebook together, and if you have questions on what that is or how to do it, talk to John or contact an educator coach in your area who can help you with that. It's literally a notebook you give to the judge that has the case and some other materials in it. So that can be something that's a little surprising for people who are brand new. Again, with judges, talk to your kids about the fact that judges are individuals. They're people too, and so they're going to sometimes see things differently. We are doing our best to educate judges about the scoring guidelines, but they are still somewhat new. If you have a judge who's been judging mock trials since the start, they may have their own ideas about what they want to see, and we can tell them over and over that these are the guidelines now, and they may still want to see things the way they've wanted them for 20 years. And so just follow what your judge is saying in that round, and just, you know, kind of prepare your kids for the fact that, you know, these are the set expectations, but sometimes a judge is going to have a different idea, and you want to just cooperate with that judge in that round to kind of protect your scores a little bit. If you have a team that's really struggling and you think you're going to need to use notes in some sort, get it down as small as you can. Can you get it down to an index card? Can you get it down to Post-it note? Particularly with 6th grade teams, they might just not be ready. And if they're not, then you talk about realistic expectations about what they can do while they're on notes, and you talk about how do we get better for next year, and then you get those notes as simple as you can to give them the best chance at success. You don't want them to crash and burn if they really aren't ready. You know, we have a wide variety of teams with a wide variety of skills throughout the state. The gold star is no notes on your feet, doing everything from memory and improvising it out when you don't know. But there are teams that don't hit that. And so you got to know your kids, and you got to give them what they need to succeed. As far as closing arguments, one thing that we found that works well is to give our timer a checklist of all of the points that are going to go into the close, because that's someone who can sometimes have an outside view on what's happening from the attorney sitting at the table. And they can just check those off as they come in, give that to the closer during the last break, and it can help be a really good sort of double check for the closer on what did and did not come in, because it's someone who's not focusing on 20 different things. I mean, they're running a stopwatch, but the attorneys at the table are you know, they're listening for objections, they're prepping for the next thing, they've got a lot going on. Having another witness do that could also work. So just, you know, think about how you can use your team well at the table to help each other out. So those were kind of my additional thoughts on that.
I'm going to take a couple minutes and talk about some perennial problems that we have that we notice at competitions, questions that keep coming up from year to year. One of the biggest sources of controversy between teams is the use of enlargements and demonstrative aids. As I mentioned before, the best thing to do is to show the enlargements that you're going to use to the other side before the round begins. If there's an exhibit that you think would be effective if it were made larger so the students could interact with it during the course of the round, make sure the other side sees it and agrees with you that, yes, that's fine to use during the course of the round. One of the other problems that occasionally comes up is a team will want to use costumes for some of the witnesses. Some of them in the past may have been elaborate. They've gone out and rented a police officer's uniform or something like that. That's not allowed under the rules, and so in order to ensure an equal playing field for all the teams competing, we ask that nobody use costumes, but that is different from the question of whether or not people should dress appropriately. And on that issue, you should consider, what would an attorney dress like? What would a witness who is a particular character dress like? And encourage your students to wear attire that would be appropriate for those roles in a professional setting, and that will be perfectly fine for the round. The focus of this is on the students' performance and what the students are able to prepare and present, not on what they're wearing. One of the other issues that comes up, and unfortunately this is one that will confuse judges from time to time, is the rule dealing with what's called unfair extrapolation, which is a rule of evidence that is special to mock trial and says that if a witness invents facts on direct examination which affect the outcome of the trial, the opposing attorney may object that the witness has gone beyond the scope of the affidavit. What that rule is designed to prohibit is a witness during their own attorney's examination coming up with new facts. For example, in the case that Van was mentioning earlier, inventing a stop sign where none exists. And if that occurs, a student from the other team may jump up and object and say unfair extrapolation. That's an important fact in this case, and it's not contained anywhere in the affidavit. The purpose of that objection is meant to call attention to the fact that the other team is trying to shift the scales a little bit by creating a new fact. As a practical matter, though, it's always better to teach your students how to deal with that kind of issue on cross-examination. If you are concerned that an attorney may be likely to invent facts, or a witness may be likely to invent facts during a round, that's a really good opportunity for a crossing attorney to practice and demonstrate the impeachment procedure, which is a process where the student uses that witness's affidavit to show that that witness has created a new fact out of whole cloth and hasn't included that in the affidavit previously. That impacts that witness's credibility, and if a student is able to perform an effective impeachment, that will reflect very well upon the student when it ultimately comes time to score. Judges are instructed on the unfair extrapolation rule. However, because it's not a rule that is contained in the rules of evidence for practicing attorneys, many judges are unfamiliar with how to apply it, and so it may just result in an overruled objection. I already mentioned the issue with talking to students during rounds. I can't emphasize enough how important it is to instruct your students and have them instruct their parents and family that may be watching that they shouldn't have contact with them once the round actually starts. That way it just avoids any problems with the judges having to address a rules violation during the round. And with that, I will turn it back over to John Wheeler, who will have some tips for you on how to navigate the tournament on the day up.
I appreciate you're all sticking with us. I know we're running a little bit over time. I promise that I'll be as brief as possible. I did want to talk about what actually happens leading up to the competition, the navigating the tournament. In advance of your regional, you'll receive an email from either me or from your regional coordinator. That will include the schedule for the day, talk about what items might be needed to register the team. Typically it would be the team roster, and more or less just letting the regional coordinator know that you're actually there. There may be a packet for you to pick up that includes copies of your ballots, copies of the time sheets. If the blank certificates have been done in advance, those can be given to the coaches as well. In that email prior to, you may also know what rounds your team are going to participate in. Typically the regional competitions, unless it's a relatively small region and there's an even number of teams, there's going to be either 3 or 4 rounds. but every team is only going to participate in 2 of those 3 or 4 rounds. What that means is that there's going to be times when you are not participating. Now, if you've got a specific request, the students all need to be back at school at a particular time, you can talk to the regional coordinator and say, can you schedule me only in rounds 1 and 2? Or if it's a longer drive and you have a fear that you may not be able to make that first round, can you schedule me for rounds 2 and 3 instead? And most often the regional coordinators will be flexible enough to make those adjustments as long as they know in advance. They may also tell you at that point which round you are going to be plaintiff and which round you're going to be defense. They won't at this time tell you who specifically you're facing, because that's all going to be kept in secret until you arrive on the site. But you may know that in round 1 you're going to be plaintiff and in round 3 you're going to be defense. This is important then to let parents know, because in many situations a student is only doing a role on one side of the case, and those parents want to take time off of work to watch their son or daughter participate, and you can then communicate that their role on plaintiff is going to be at this time in the morning or this time in the afternoon. Again, if there are specific requests, if you know a parent can only come at this time and you really want to have them see their son or daughter participate, you can request that from the regional coordinator. Again, the more lead time, the more apt they're going to be to honor that request. You'll also notice that you'll be given a random 3-letter code. Some of the teams end up making weird acronyms out of those 3-letter codes. I try to weed out the obvious and inappropriate ones in advance, but that doesn't stop the teams from making not so obvious but equally inappropriate codes out of them. I appreciate the cleverness. I don't really appreciate the inappropriate ones, but you will get a 3-letter code. It's important that the parents know what those codes are, because everything at the regional competition will be done in code. There'll be a posting board that has team ABC facing team XYZ, and if the parents know that you are team ABC, they know that they can go to that particular room for that particular trial. The pairings at the regional competition are done in advance, and they are done in a random fashion. It's impossible to power match when you are having teams going in 2 out of the 3 rounds. And so I do my best, or the regional coordinator does their best, to pair teams together in a random way. You know that if you have 3 teams or fewer from a particular school, you will not face that other team from that school in the regional competition. But if you have a lot of teams, 7, 8, 10, there is a chance that during the regional preliminary rounds, 2 of the teams from the same school may meet. That's just to try to keep things fair. The number of bids to the state competition is determined by the number of overall teams in your competition, in your region. So there are 32 bids to the state tournament. We just prorate each region. So if you're in a very large region, you're going to have more bids to state. If you're in a very small region, you're going to have less bids to state. And it's all done with a mathematical formula. Just a couple of quick things to kind of wrap it up. First of all, I want to thank our experts for their time today. Christina, John, and Van all have busy law practices and have had to take some time off this afternoon to work with you. I would also invite your questions or comments about this program. If you want more webinars on specific topics, go ahead and request those. We can probably work that out. If there are some specific questions that you have about how the whole process works, feel free to email me, or I hate to say this, but you also now have my text number as well, and you can send me a text. Do identify yourself in the text. I get random texts all over the place, and I have no idea who's actually asking the questions. But to finalize things, there's a couple comments I wanted to make. Doing a mock trial is like putting a jigsaw puzzle together. Except unlike the puzzles that you will buy at a store, there's no picture on the cover. And unlike jigsaw puzzles you buy at the store, there will be more pieces than you need. I like to characterize it as a 500-piece jigsaw puzzle with 1,500 pieces. And all of the pieces are roughly the same size and shape, so the finished product could look markedly different from one trial to the other. There is no wrong picture. It's just which pieces you choose to use and how they fit together. They could be as elaborate or as simple as you choose to make them. So there's no wrong way to do that. One of the things I started out with is saying that one of the things that mock trial does is allow for community involvement by getting attorneys in your community involved, by getting parents with specialized knowledge, especially people who are involved in community theater, or if it's a case about a specific topic, to get a participant of that. If, for example, there's a police officer, to invite a police officer in. If it's an arson case and it involves fire department, to bring in an arson investigator or a firefighter in to talk about the case. But remember at the middle school level that your community also includes the high school. And this is a perfect opportunity to invite high school students who are involved in mock trial to help with the middle school. It helps two ways. One, a lot of times middle school students will actually listen to high school students, whereas they might not listen to you. High school students are closer in their age, they've had this recent experience, and so they may be a voice of trusted authority. Second, and selfishly for the high school mock trial program, is it gets those high school students involved in the process before their case comes out. They look for those opportunities and want to get involved. So if you have a high school program, look for ways to get those high school kids involved, either working with specific groups, a direct attorney and a witness, or with a specific witness. Just invite them to practice to kind of corral the herding of the squirrels, which is dealing with middle school students. Just find a way to get them involved, and I think it'll be a more meaningful experience for the middle school students and for the high school students. If you don't have a high school program, you will eventually, because these middle school students you're working with will bubble up, and then they will want to hopefully be bitten by the mock trial bug and want to give back to the program and keep doing it. Two other quick things. One, we were talking about demonstratives and clearing it with the other team beforehand. I'm just going to give one bit of my pet peeve or one bit of advice. In most cases, there is some sort of a map. And I'm going to break out in song because one of the shows that I watched ad nauseum as when my son was younger was Dora the Explorer. And Dora would always say that if there's a thing you want to know, if there's a place you want to go, find the map. And then find the map, find the map, find the map, find that. And now I'm going off. But if there is a map, use the map. And it doesn't even have to be an enlargement. The point of mock trial is not to have you spend extra money to make these elaborate enlargements. You can just use the map that is included with the case materials. But mock trial is primarily an oral process. If there is something you can do to break up that oral process and make it something other than an oral process, i.e. a visual process by using a map, take that opportunity to do it. It will wake the judges up if they happen to be snoozing. It will direct their attention to a specific point you're trying to make, and it will demonstrate that you know how to handle the use of an exhibit and or an enlargement in your trial. So there's lots of good things that will happen when you use the map. And finally, this is stepping out of my role as competition coordinator and my role of a mock trial dad. I've never had this experience before. My son is now in 6th grade and is doing mock trial for the very first time. Believe me, I feel for all of you who have done this as coaches or as parents. You teachers, I don't know how you do it with the middle school kids, but it makes a huge difference, and I'm seeing this whole process from a different perspective as being the dad of a mock trialer. Now, I'll reassure you that my son had absolutely no inkling of what the case was about. I was writing it with the firewall in our house. After he went to bed was when I did most of the writing of the case. When the case was released, then he started to ask all the questions, and most of my answers are, ask your mom. Because number one, I really can't talk about it, and number two, she's actually the practicing attorney, so she's probably got a better answer than I do. So I really appreciate the time and the effort that you're taking with these students. Believe me, the number of students who stop me at Target or at Hy-Vee or send random emails or text messages to me throughout the year let me know that you're doing an excellent job, that what these students are experiencing now will stick with them for a long, long time. And they won't remember the score necessarily, although I think Van probably remembers every 10 he ever got as a high school student. But they will remember the time that you've taken with them, the time your attorney coach has taken with them, the comments that the judges have made at the competition. It really is a life-changing experience. Not all of them are going to be attorneys, but all of them will live in this rule of society ruled by law and would be better because of their participation in mock trial. So I want to thank you for your time today, joining us in this webinar, and invite you again to submit questions to me via email or text message. And if there is a need for additional webinars, to please shoot those ideas to us so that we can plan some additional programs. So thank you again for your participation in Iowa Mock Trial 101. Thanks so much.